what I like to call, and apparently Mr. John disagrees with, the mighty OGO. Now, pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, October 17, 2022, the committee is meeting on the study of the ArriveCAN application. As usual, please keep your pieces away from the microphones as it causes feedback and potential injury. Just a quick update on some documents that have been ordered. Mr. Firth from GC has contacted the committee regarding bank records related to GC, and we are expecting them to arrive today, which of course then will go out to for translation. Now, before we start, I'm going to just do chair's prerogative. It is my wife's birthday, and I know she's watching on. I know she's watching on CPAC, so I want to wish my Okay, my wife Sasha, happy birthday. Being related, of course, with OGO, I am cheap. This is her birthday gift, and I'll be bringing her a gift wrap. I'll be bringing home a wrapped copy of the supplementary Bs.
Nice swallow of wine for your wife. Come on,
Yes.
Point of order, Mr. Chair.
Yes.
Yes. When I believe I might have informally communicated that I would like to see a list of the documents that we have asked for. As I would like a list of the documents we asked for, a list that the dates that those documents were expected, and then whether or not we have received those documents as of yet, just so that we can remain current as to which documents are submitted and which are outstanding.
Yeah. I suspect we'll have an update by the end of the meeting. We're waiting for a bit of information to come in on a couple items. Yeah. Anyways, we'll start with our opening statement. Mr. Mills, welcome back. You have 5 minutes.
Bonjour, Monsieur le Président, membre du comité.
Good afternoon, Mr. Chairman and committee members. I would like to thank you for the opportunity to appear before you today to describe Public Service and Procurement Canada's role in supporting the Canada Border Services Agency on the ArriveCAN network. I'm joined today by 3 members of my team working under our Professional Services Procurement Directorate: Angela Durrigan, Manager; Silvana Mansour, Team Leader; and Anita Chan, Procurement Specialist.
For frontline operational procurement officers to be called to testify in front of parliamentarians. I would like to thank them for joining with me today to be here and to support the committee's study by providing more insight into procurement and the roles of procurement professionals. Before we begin, I would like to acknowledge that the land which we gather today is the traditional, unceded territory of the Algonquin and Anishinaabe people. In the earliest days of the pandemic, when the Government of Canada, like all other governments, was working flat out to respond to the pandemic, the procurement professionals at PSPC worked tirelessly to support departments and agencies to source supplies and suppliers in support of their response. To put this in perspective, this was the early days of the pandemic when there were lockdowns across the country, hospitals were operating beyond capacity, people were sick and dying. It was also a time when supply chains broke down, and it was very, very difficult to source supplies and to find service providers. At this time, the Canada Border Services Agency analyzed its internal capacity and did not have the capacity to develop an app with just their staffing resources. As a result, CBSA contacted our department for an urgent requirement for professional services to support the development, integration, maintenance, and an urgent tool to support the implementation of border measures to reduce the risk of importation and transmission of COVID-19. This would become the tool that we now know as ArriveCAN. CBSA looked at various options to deliver their application, including leveraging internal staff. However, this option was discarded as they did not have the capacity or the technical know-how to develop an app of this complexity with their staff available. To find the IT support that it needed, PSPC helped CBSA access resources under several PSPC managed professional services methods of supply and put in place new contracts to fulfill their requirements, some of which were issued under emergency contracting authorities. Based on the information received from CBSA today, a total of 46 contracts were used in whole or in part by the CBSA to procure professional services, software licenses, and support to develop and maintain the ArriveCAN app. 31 of these contracts were awarded by my department. Out of these 31 contracts, 19 were competitively awarded under pre-established supply arrangements. 8 were to procure software licenses where it was necessary to use sole source contracts due to intellectual property rights or an urgent need. and 4 were sole source contracts for IT consulting services due to the pressing emergency. To be clear, the government contracting regulations and the associated policy framework allow PSPC and departments to enter sole source contracts when there's a pressing emergency. The pandemic was such an emergency. Further, in order to support the execution of an effective and rapid government response to COVID-19 global pandemic, TBS approved time-limited increases to those emergency contracting authority limits. For 23 contracts, the work was authorized as and when requested through task authorizations. Most of these task-based contracts were put in place using the government's pre-existing methods of supply. Ces arrangements permettent au Canada de solliciter des
These arrangements allow Canada to solicit proposals from a pool of pre-qualified suppliers based on a list of predefined criteria and to take advantage of pre-established contract terms and conditions.
efficiency to the procurement process, provide clients faster services with less collective administrative costs. By design, they provide a framework for client departments to put in place their own contracts and task authorizations much easier and to administer their own contracts. Under these arrangements, client departments develop statements of work, evaluation criteria for the selection process. If the contract value is under 3.75 million, the department can serve as the contracting authority, run the procurement themselves, and process to put in place the contract. If it is over 3.75 million, PSPC administers selection and contract award. In both cases, it is the client department that evaluates technical proposals, conducts verifications of certifications. PSPC as contracting authority undertakes the financial assessment and applies the evaluation criteria to recommend a winner. We all verify company and individual security clearances at the time of award. We also award the contract once approved by the client department. These contracts allow CBSA to move quickly to bring in the resources they need with the specific technical skills at the different points in the development of the app. Once the contract is in place, it's administered in a shared responsibility between
Sorry,
PSPC.
Mr. Mills, you're at your 5 minutes. Can you wrap up briefly?
Yep, I will wrap up very quickly. Sorry. I would just like to conclude by noting that IT contracting is a very important area also for the support of small businesses in Canada, in particular Indigenous businesses. At this committee, you heard from Dalian, who is an Indigenous business. Under the procurement strategy for Indigenous businesses, federal departments and agencies can set aside contracts where there's known capacity amongst Indigenous businesses. Dalian was such a business. What is important to understand is under the procurement strategy for Indigenous businesses, 33% of contracted or subcontracted resources must be Indigenous, not for a particular task authorization, but for the overall value of the contract. Therefore, Indigenous businesses can subcontract with non-Indigenous businesses. Again, I'd like to thank the committee for having the opportunity to be here, and we're happy to take your questions.
Thanks, Mr. Mills. Ms. Kusi for 6 minutes, please.
Thank you very much, Chair, and thank you to the witnesses for being here today. Mr. Mills, you started off by saying that it is extraordinary that you would generally have, if I may say, the middle managers, not the top officials. Yeah, that absolutely is extraordinary. But what's also extraordinary is that Canadians paid $54 million for the ArriveCan app. What's even more extraordinary than that is the RCMP investigation we have now, which has allegations of forged resumes, identity theft, collusion, and fraudulent contracting. So, I mean, that's really extraordinary. What's also extraordinary, Mr. Mills, is that this government has a history, actually, of not listening to women, for letting the men speak for women. You can talk to Jane Philpotts if you want to about that. You could talk to Jody Rayson-Wilbode about that. You could also talk to Selena Sujar-Chavez. And finally, I'll say, Mr. Mills, we originally invited these 3 women, understanding that they would be perfectly capable of responding for themselves. And if you don't mind me saying so, this committee actually has a history, unfortunately, of senior executives within the government not necessarily telling us the truth in this committee. And unfortunately, I think it's a result of their political masters, but that's certainly a deeper conversation. So with all of that, Mr. Mills, I do believe.
Je pense, compte tenu de tout cela, que nous devons peut-être en tenir compte pour les 3 personnes qui sont impliquées dont nous avons demandé la comparution aujourd'hui.
As such, oh,
Sorry, one moment, please. We're in
Thank you.
translation.
Yep.
Interpreters mistake, wrong channel. Apologies.
Working again in translation?
It's working now. Yeah, keep going.
okay, ça fonctionne now. That works right now? Okay,
It is now working.
Mr. Chair, can Ms.
Yeah.
Kuzi just go back like 30 seconds? I think we're just getting.
We will if once we get it working.
The interpretation is now working.
They just picked the wrong channel. That's okay. Nobody's saying anything. That's why she cannot verify whether you're saying.
All we're saying right now.
It is now working, Mr. Chairman.
Can you try
It is now working. Checking the English channel. Checking the English channel. Checking the English channel.
we're fine now? Okay, thanks. You're at minute 30, and if Mr. Johns asks you, just move back about 30 seconds. I'll make sure the time is reset. Go ahead.
okay, so, pardon me. So that leaves me with 4 minutes and 30 seconds. Okay, thank you so much. So, Mr. Johns, what I was saying, what I was trying to explain to the two witnesses that we originally had not invited was that unfortunately, Mr. Johns, as you well know, we have a history in this committee of senior government executives not being forthright with us, not necessarily telling us the truth. I guess in this room, I can say, frankly, lying to us, as was evidenced by the story recently in the Globe and Mail from Bill Curry. So you will forgive us then, please, if we direct our questions to the three other individuals, Ms. Durgan, Ms. Chan, and Ms. Mansour here today. And I'll start now. Ms. Chan, why did you determine Bottler's contract to be between Bottler and the subcontractor?
That will start off with an investigation on our part once we receive the first complaint from Ms. Studd alleging that her name as well as the name of Mr. Moravev were used in a TA without their consent, and work was being conducted and the work was paid to the contractor on file on the contract, which is Dalian and Corrales in joint venture. So from when we inquire further with the representative of Corrales, they informed us that in fact both resources were provide the sub.
You're
sorry.
doing great. Keep going. Thank you.
The work provided from the resources were provided from a third party, which was GC Strategies. From our perspective, because Dalian and Corrales did comply with what we asked for, there was a term in out of the ordinary from our audit. They did not actually breach any contract or any terms to the contract. From then on, it's a dispute between the resources, GC Strategies, and the contractor. And Canada has no purview in this dispute.
Okay, I do disagree with that. I do believe that the information that I have here states that in any subcontract other than a subcontract referred to in paragraph 2A, the contractor must, unless the contracting authority agrees in writing, ensure that the subcontractor is bound by conditions compatible with and in the opinion of the contracting authority not less favorable to Canada than the conditions of the contract, with the exception of the requirements under the Federal Contractors Program for Employment Equity, which only apply to the contractor. So the information that I have here doesn't necessarily corroborate with that. But Ms. Mansour, what made you confirm with Ms. Chan that the issue was between the contractor and the resources?
Our contract is with Coradix and Dalian. Those two resources came to light as Coradix had subcontracting to GC Strategies, and GC Strategies proposed them as resources. So we have no stand in to interfere in subcontracting because it's not the prime contractor with whom we have the contract.
Yeah, you certainly always have standing when you're dealing with taxpayer money. Ms. Chan, what was your understanding of the situation when you wrote Ms. Julie Prudhomme of Cordix about TA number 2021002043? Are you at?
Thank you for the question, Mr. Chair. Are you asking me from my understanding?
As to what was going on when you wrote with just the uncertainty of this situation?
Okay, please keep in mind that the only information that was brought on to PSPC was the email, was a complaint from Ms. Stutt. So the email states that her name as well as Mr. Moravev were used without consent or knowledge to this particular TA. Obviously, we want to investigate this because their claim is frankly quite severe.
Yeah, that is, sorry, that is our time.
Thank you, Chair.
Mr.
Thank you.
Baines?
Thank you, Mr. Chair, and thank you to all of our witnesses for joining us today.
You muted yourself, Mr. Baines.
Okay, sorry. Your cooperation here is, greatly appreciated. After several meetings, we're still trying to unpack and piece together like what's taken place here. So what I've learned here, what we as a committee have learned, so my understanding, ArriveCan isn't under investigation, but allegations from Bottler about a tender to build a sexual harassment app is now being reviewed. While the total $55 million cost of ArriveCan and its 70 updates reflects development, updates, information security, data management, cloud services, but it also saves $3 per traveler when compared to the old paper system. So we sort of learned that it was actually, cheaper, and it was done in record time under the circumstances. And Bottler's principal issue here is a contractual between themselves and Cordix and Dalian. Bottler Inc. was to conduct a 6-month proof of concept for their software at the CBSA with the potential for broader government use. Payment issues arose. Bottler claims to have received only 2 installments totaling $112,000 of the promised $336,000 for their software configuration work. So numerous allegations of individuals misleading this committee, from public servants to Bottlers themselves. Like, this is sort of where we're at right now. And my first question is to Mr. Mills. At the heart of this situation, the dispute between a subcontractor and a federal government supplier that began with claims of non-payment. How often would you say PSPC hears from subcontractors in a similar situation or dispute with contract holder? Is this common, rare? What can you expand on this?
Mr. Chair, thank you for the questions. We do about 10,000 contractual measures a year. So, and many of those contracts involve subcontracts. So I would say that unfortunately, it is common in certain cases that there will be disputes between prime contractors and subcontractors about payment. This is part of the reason why our department has been very active in spearheading efforts for prompt payment requirements so that we can ensure that prime contractors pay their subcontractors in a timely fashion after the Government of Canada has paid out claims. I would say,
if this is common, what's different here in this situation?
what I'm not sure I can answer what's necessarily
No, if that's
different.
common, if there are disputes, but like, why is this situation come to the forefront in this manner?
I would argue, Mr. Chair, that this has come through because of the allegation that there was misappropriate use of their subcontractors' resumes and credentials in terms of obtaining the work. But in terms of from a contracting perspective, in our understanding, this was a task authorization that was issued to a company that had a task-based contract. It was issued as a piece of IT work within that the task-based contract was for IT work. So it was a task authorization that was fairly general that said they were going to do feasibility work in the IT space under an IT contract. And with that task authorization, it didn't name who the resources were, and it did not name Bottler. It was only after they made the allegation that their resumes were used and put forward by GC Strategies that it came to light that there was these issues.
And then what's PSPC's role in a dispute like this then?
So maybe I would turn to Angela or someone to explain what we would normally do
Sure.
when the dispute comes in.
So with respect to this dispute,
Correct.
so in cases where we would seek subject matter experts, in this particular instance, we sought legal, we consulted with justice. And from there, we made a determination on how we would proceed. And again, in this instance, as directed by Ms. Chan, we found based on information that was provided to us by both Caradix and Dalian in joint venture, as well as CBSA, that we took that information and determined that it was a dispute between the subcontractor and in this case, a subcontractor. And again,
And then does government intervene? Like, for example, ever pay a company subcontractor directly, even if there's isn't any contractual relationship with that company?
so we did not under this circumstance have a contractual obligation or a contractual situation with Bottler, nor did we have one with GC Strategies. Our contract is with Dalian and Caradix in joint venture. With respect to that, we advised Bottler as such. And with respect to payment and the TA itself, CBSA determined that only 2 of the deliverables were accepted, and they provided payment to those 2 deliverables through Dalian and Caradix. Thereafter, it is our understanding that the TA was amended to close out with only those 2 deliverables having been completed.
Okay, so would you say PC's standpoint, from your standpoint, the standard procedures were followed in this particular dispute?
Yes.
Great. That is our time. Thanks, Mr. Baines. Mrs. Vignola for 6, please.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Over the past few weeks, an anomaly was brought to the attention of the public and the committee regarding a contract by Caradix and Dalian that also involves Bottler and GC Strategies. This all happened roughly at the same time as GCS, Dalian and Caradix were working on ArriveCAN. So my first question to Ms. Chan. When these 3 companies were working for ArriveCAN, were any subcontractors not paid within the time they should have been? Thank you for the question, Mr. Chairman.
You're asking me for if I have received personally any complaints from subcontractors on the list, on the TAs for the contracts that I have on my file that I have visibility on during the course of any work that was performed on ArriveCAN. Is this correct? Not to my knowledge. The Bottler TA would be the first instance.
Là, je parle pas de.
I'm not talking about the Bottler TA, but I'm talking about GC Strategies, Dalian, and Caradix in relation to ArriveCAN. Were any subcontractors of those 3 companies in touch with you or with members of your team to say, this isn't working, I'm not getting paid? Personally,
in this case, but I do not have visibility on all the contracts that have been issued for the work of ArriveCAN.
Est-ce qu'il est possible de vérifier auprès des gens qui.
would it be possible to check with people who are managing contracts associated with ArriveCAN? Could you see if they received complaints about subcontractors not getting paid? Mr. Mills?
Mr. President, we we would happy to undertake with CBSA's Chief Financial Officer, who's responsible for paying invoices to see if they've had complaints of non-payment from subcontractors.
Merci. Monsieur Mills,
Thank you. Mr. Mills, do officials in charge of communications between these companies, have they had to intervene to make sure that these companies actually paid their subcontractors?
Mr. President, it's not our normal process to verify with subcontractors after payments have been made out whether primes have paid their subs.
merci. Les antécédents.
Thank you. Legal and professional records and security ratings for subcontractors were the conditions, were the fact that the subcontractors supposedly met conditions like security ratings verified for subcontractors.
To the best of my knowledge, the security requirements for subcontractors were verified by CBSA.
Avez-vous reçu des signaux d'alerte?
Did you receive any alerts from officials who felt it would be necessary to review the statement of work and the procurement process because they comprised irregularities that made them uncomfortable about Arrive-Can contracts when it came to GCS, Dalian, and Corridix?
Mr. Chair, I did not receive any complaints personally about anyone having concerns with the statements of work with respect to those contracts. I don't know if anyone else amongst our team received any complaints.
I have not.
Avez-vous vérifié qu'aucun curriculum?
Have you checked that no CVs were altered to meet the requirements for the task authorizations by Corridix, GS Strategies, or Dalian?
Mr. President, when the contracts or task authorizations are let, it is actually the responsibility of the department, the technical authority, CBSA, to verify that the resources put forward have the credentials required to carry out the work. So in terms of reviewing the resumes and the qualifications of the subcontractors and their resources, that work would have been conducted by CBSA. You would have to ask them in terms of what work they've done to validate and review.
Au niveau des livrables et des étapes de livraison.
Regarding deliverables and steps in delivery, were you assured that they respected and complied with the general procurement processes for Corradix, GS Strategies, and Dalian?
That we're talking about the division of responsibility with respect to contracts, and it is the responsibility of the contracting department, CBSA, to verify the receipt of deliverables and to make the payments based on their receipt and acceptance of deliverables under contracts.
Est-ce qu'il est habituel de voir qu'une...
Is it usual for a recruitment company to hire another recruitment company to hire resources for a given contract?
I would, Mr. President, I don't know if it's typical to have multiple layers of recruitment companies, but I will say that in very complex IT projects, it is typical that there will be a number of subcontractors. Many of those subcontractors will actually be individuals. Those individuals will be incorporated individually. So it may look like there are layers of subcontracts when it's actually the subcontracting entity is actually an individual in that contract as a corporation.
Thank you, Mr. Mills. Thank you, Ms. Vignola. Mr. Johns, please.
Well, before I jump into my questioning, I want to ask you, Mr. Mills, is it typical and what is the threshold of commissions on contracts? So you've got a contractor who can take 15 to 30% commission. They can subcontract down to a subcontractor. They can take 15 to 30%. What is the limit on how far down the line it can go and how much can the commissions actually be? Total, what is the absolute total? All the it goes contractors, subcontractors. How much commission can be paid out?
Mr. President, I think to begin, I would note that most of these instruments and the TBIPs is a competitive instrument. So when we put out a requirement, it is actually a requirement to compete that amongst many firms. It is typical
bet
that
it
we have
is.
many respondents, and that a lot of the selection and the winning is based on the price of each of the resources at the different levels. So you may have a requirement that says we need a web developer, we need a security
Okay.
specialist, we need
I'm
senior.
just looking for an answer. I'm actually looking for an answer. Is there a set amount, maximum allowed to be paid in commissions through this chain of contractors, subcontractors, ghost contractors, and everybody taking a cut? Is there a max cut that can be taken? That's all I'm asking. Is there a threshold? Is there any regs in there to make sure that there's a set amount that can only be paid out, like maximum on a project?
There is not a set of regulations that bars it, but what I would say is that these contracts are awarded under competition, where it's the market rates that are prevailing that are limiting how much firms can ultimately charge.
Well, this is no surprise why outsourcing's gone up, fourfold under this government and double under the previous government. This is out of control. I'm going to ask Ms. Jurgen, would you be able to, around the task authorizations that GC Strategies provided to this committee last year, you signed for 2 task authorizations, 2022-00080 and 2022-016-142. These task authorizations were for a total of $10.2 million. However, the prime contract they were issued was only for an estimated cost of $2.35 million. Now, my first problem is that the task authorizations can exceed the value of a prime contract, yet these tasks are more than 4 times the value of their contract. The second problem is that the contract they were issued under appears to not exist. GC Strategies didn't provide it to this committee. It doesn't exist on the Canada Buys database. There's no record of it existing. So first question is, how are task authorizations that were more than 4 times the value of their contract even permitted to be issued?
So if I did sign a task authorization, I would have verified it against the contract and ensured that it was issued outside under a specific awarded contract. I would have to see the task authorizations that you are referring to, and I would be happy to, if you presented those to me, I would be happy to come back with that information for you.
Yeah, if you could table that to the committee, and you're willing to, that would be appreciated. I think if the committee, if I have permission to ask the witness to produce those within 3 weeks.
Yeah, we're fine, Mr. Johns. Thanks.
Great. Second, does the prime contract cited in these task authorizations exist? If so, can you provide it to this committee and tell us why it isn't publicly disclosed?
If you provide me the task authorizations, I can make that reference, certainly.
I cited those numbers, so I'm hoping that you can table those numbers that I cited. Is that agreed?
Yeah, the clerk will follow up with the what you've cited in the blues and get it to Ms. Durgan.
Can you also, table Ritika Dutt and Amir Morzhev's consent to be named in the task authorization? Can you table those documents?
So you're looking, sorry, can you repeat the question and just reaffirm what exactly you're looking for?
To table Ritika Dutt and Amir Morzhev's consent to be named in the task authorization.
Mr. President,
Certification of personnel.
with respect to certification of personnel, is optional whether they are actually requested. In this case here, we would have to go back to CBSA to see whether or not they actually requested those documents.
I'd like permission from the committee to have those documents tabled to the committee. Indigenous set-asides, I previously told this committee how much I
Can
value
I
the
interrupt for a sec,
procurement
Mr. Johnson? I'll pause your time. Is this a request from the committee for an order of production documents or a regular? Okay. Members, we're fine with that?
Yes.
No, I think, were you asking Ms. Durgan or from Mr. Mills? Or just from?
For Mr. Mills, he can make the request to CBSA and provide them to the committee.
Okay, that's
I
fine, Mr.
previously told this committee how much I value the procurement strategy for Indigenous business, and I think we all should, and how critical Indigenous leadership and involvement in procurement is. It's something New Democrats have been fighting hard for, especially in procurement opportunities that directly affect Indigenous communities. I want to make sure what's happening with these set-asides, but what I've heard, it doesn't seem like it is what's supposed to be. PSPC's rules for the program are rightly set up to make sure that work doesn't simply get subcontracted to non-Indigenous entities. But when I asked Dalian about how they subcontract Indigenous set-aside contracts, I was appalled by their answers. They did not acknowledge the requirements for subcontractors to be Indigenous. In fact, Mr. Yao, said the rules allow us to hire pretty much whoever we want. He also told us that the Indigenous set-aside requirements are audited on every joint venture Dalian and Cordex do. Is it true that this is being audited on every joint venture they do? And is it true that Indigenous Services Canada has audited the bottler work in particular, as Mr. Yao claimed?
Yeah, we're out of time. Is it a quick yes or no, Mr. Mills?
It's a quick answer. Mr. President, you'd have to direct that question to Indigenous Services Canada, who administers that program.
Okay. Mr. Brock for 5 minutes, please.
Thank you, Chair. Ms. Chan, does PSPC have its own legal department?
Thank you for the question, Mr. Chair. We consulted with Legal Adjustments Canada.
Okay, so nothing internal? Do you have a particular lawyer that you deal with at the DOJ?
Not that I'm aware of.
Okay. There's a reason why I asked you that. So I want to go through a thread of emails between yourself and Ritika Dutt. She brought to your attention on May 10th, 2023, a number of concerns that Coridex and Dalian were using their names as resources without their knowledge and consent and received payments from the government under the TA. That during the bidding process, they falsely claimed that they had been in contact with Bottler and sought their input. An ATIP with CBSA confirmed that there was no fixation of status of personnel on file. They in fact filed legal notice to the contractor to produce the document, and they failed to comply. They sought your help to compel the contractor to produce the document. There are elements of criminality in that email, that not only is there potential breach of contract and regulations with respect to the TA, but we have elements of fraud and forgery. Did you get a sense that there was a red flag in this, and whether or not you passed this on to the GOJ for consultation? Yes or no?
We did pass along what we found, and we were in constant consultation throughout the course of this investigation.
Did you consult the DOJ in relation to that email?
Yes.
You did? Did you get a legal opinion?
Yes.
Okay. And the legal opinion, without getting into specifics, but allowed you to continue pursuing that documentation that they requested?
While we had.
Yes or no?
While our first and foremost priority was to protect Canada and to investigate whether or not if the allegations of fraud from the prime contractor occurred.
Yes. Okay. So you sent an email to Julie Prudhomme on May the 26th requesting information from the contract regarding the allegations. May 26th, you received a further email from Bottler that they were never contracted by Cordex to provide any feedback on the TA, did not provide recommendations on any resources, that the mandatory requirements table for herself that was submitted with the TA significantly inflated her work experience and not reflective of her actual work experience. She did not agree or consent to be named on the TA or for the work to be implemented. Again, the specter of criminality. And now we have got the specter of a forged resume. Another red flag. Did you send that particular email to the GOJ for consultation?
Yes, I have.
Okay. Now, we already know what the evidence was. Okay. Christian Firth has testified, and his illogical fantasy of simply making a mistake could have been believed if there was one modification to Ritika Dutt's resume. But memory serves me correct, without looking at the transcript, that he had attempted on at least 5, if not 6 occasions to deliberately manipulate the work experience so that when they inputted that data on the required forms, that they would qualify for funding. That is not only forgery, that is fraud. So my question to you is, why did you not just shut down immediately this operation between GC Strategies, Coredex, and Dalian against the specter of criminality? It's obvious. Was it not obvious to you? I'm not asking Mr. Mills, I'm asking Ms. Chan.
All right, thank you for the question, Mr. Chair. Again, our priority was to investigate the allegations made to Dalian or Carotics. When we asked Dalian to provide documentations that they did receive payments from CBSA, and they did pay out, as we found out later, that they were provided the resources from GC
Okay,
Strategies.
I'm not talking about that. You have a specter now of fraudulent resumes. Did you go to GC Strategies? Did you go to Coredex and say, what is going on here? You are misleading the government. You are abusing taxpayer monies. Did you do that, Ms. Chan? Ms. Chan?
Very briefly, please.
I'm analyzing data, and from what we observed was that Dalian Carotics were obtained those documents from GC Strategies. What we found was that there was nothing out of the ordinary with the contractors.
Thanks, Ms. Chan. Mr. Souza for 5 minutes, please.
Ms. Dorgan, Ms. Chan, Ms. Spencer, thank you for being here, and I appreciate you being here, and I understand this must be difficult at times, and I just want to clarify something that was stated earlier. It's my understanding that you've agreed to come, but you've also asked for your colleagues to be here as well. Is that correct? Were they told, but did they say they wanted to come, or did you request them to be here? Like, how did that come to be? Ms. Durgan?
We're just coming as a representative of the 5 of us for PSPC with all of our different, expertise, if you will,
Right.
and levels. So.
And do you feel comfortable that the other 2 are here? Because we only asked for the 3 of you, but I just want to make certain that it's something that are not uncomfortable having. Like this, my understanding was that you've asked for some backup in case it become more complex.
No, we appreciate the support and we have no issue with them being present with us.
Great.
Point of order, Chair.
Please go ahead.
With great respect for these witnesses, I mean, they're being put in a very strange position by Mr. Souza's question, because they're like, these are the people they work for on a daily basis. So I think he could focus on the issue at hand.
Mr. Generous, I'm gonna say, it's Mr. Souza's time, and I'll let him ask his questions.
Ms. Chan, there's obviously now an investigation underway, but is this an investigation around ArriveCan?
Thank you for the question. No, it's not.
There is, however, a review, an internal review, and there's also a review being done by the RCMP in regards to this particular issue with regards to bottlers' allegations. Have you been contacted by RCMP?
I have not.
Ms. Mansour, have you been contacted by RCMP?
Not yet.
Ms. Durgan?
I have not.
Gentlemen, have anybody contacted you regarding this issue?
No.
In regards to the contract, I'm not really sure who to ask this, but Ms. Durgan, I'm going to go to you on this one. I'm going to try to respectfully ask the 3 of you on these issues, and I do appreciate backup where necessary. In a contract like that, which was just done in respect to the bottlers issue, Coredex and Dalian received the contract. They were bidders, and they won the deal. Thereafter, commissions, splits, who they hire, what they subcontract with, is not subject to increased pricing. Correct? It's based on what they were contracted to do. Is that correct?
Correct. They need to follow up on the pricing schedule that was listed on the contract.
So when they say they received a cut or they received commissions, these are individuals that are corporations. So they're subcontracting themselves. Like they're working in regards to deliverables that are required. Is that right, Ms. Durgan?
Yes, we don't have any oversight on what commissions are, or what the cuts are, or how payment is made between prime contractors and subcontractors. Our calculations are based on the firm per diem rates that are in the contract.
So Ms. Mansour, are these contracts inflated thereafter? Or are they just what they are? And then whatever happens in the tail end, that's between individuals amongst themselves, how much they're going to share of the pie. Is that correct to assume?
This is a competitive contract, so the rate we got was on a competitive base. We cannot inflate it after the fact. Once it's in the basis of payment, it remains, the per diem rates do not change.
Did Bottler, they mentioned that they had active engagement with the government as they wouldn't be required in order to deliver. Were any of the three of you involved in ongoing contacts with the entrepreneurs, the individuals? No. Just for the benefit of the committee and those watching, Ms. Dorger, can you tell us about your training? Like, what is it that you guys are trained to do?
We're, I guess, subject matter experts. We're in procurement. I myself have been working in procurement for over 20 years, with 30 years in the federal government. Most of that 20 years has been in IT professional services as my forte, if you will. And I manage a team of procurement officers who will provide acquisition services to other government departments for IT professional services.
Ms. Chan?
I started my career in the government in the intern officer development program in June of 2019. I went on various assignments, and then in August 2022, I returned back to EL division under Angela DeGrin.
Ms. Mansour?
I've been with Public Services Government Canada for 23 years, 17 in IT professional services, and 2 years in goods.
That is amazing. And that is, and I appreciate your technical expertise and
Thank
subject
you.
matter knowledge.
Thank you for that, Mr. Souza. Ms. Vignola for 2.5 minutes, please.
Merci beaucoup. Je vais
Thank you, Mr. Mills. I'll come back to my last question. Why, and I really wonder about this, why can a company, a recruitment company, be awarded a contract and then have to subcontract a different recruitment company, which in turn does the recruiting from wherever? Why was the initial recruitment company taken on if they didn't have what it took to hire the resources needed for the contract? We see this with Bottler. I'm thinking about ArriveCan and all other instances where this might have occurred, that a contractor, a recruitment company, subcontracting a different recruitment company, I think is just bizarre. Why not hire the right recruitment company in the first place?
Thank you, Mr. President, for the question. In certain cases, as in this case, there are two types of task-based contracts, one of which is deliverables-based and one of which is individual-based. In the case of deliverables-based, it is the requirement of the company to figure out how best to bring the resources to meet the requirement that the government puts forward. Sometimes in those cases, you have a recruitment company, as you call them, that has access to a wide variety of resources, but there may be some specific technical resource that they don't have relationships with. And in this industry, they may partner with another company, which in itself has access to other resources to bring those people in to deliver a deliverable such as this. In most cases, at the beginning, if it's the task base where we're looking at in terms of professionals, the professionals are identified and the skill sets are identified, and we are picking firms that already have relationships, have subcontractors, and have employees that have those skill sets.
dans le cas de Butler and I.
In the case of Bottler, Dalian and Coradix didn't have the resources, and GC Strategies had one or had been recommended one. And so they went through GC Strategies. but still got the contract at the outset because they didn't have the right resources. That's really quite astounding.
Initially with Cordet Stallion, it was for a wide range of IT services. Not all of the services under the contract were identified at the beginning. As I think testimony is shown before on this, there was a requirement to design something to aid the department in terms of their approach to addressing sexual harassment, and that's why they brought in the GC strategies and Butler.
Thank you very much. Mr. Johns, please.
So PSPC is also responsible for ensuring that contractors qualify for task authorization. So Ms. Dutt and Mr. Moore, each had 7 years of relevant experience. They needed 10 years to qualify for the work, and fraudulent qualifications were submitted for them without their knowledge, which you heard about at previous testimony of this committee. Have you figured out how this happened, who is responsible, and how will you make sure it doesn't happen again? And are you going to check GC Strategy's previous submissions to find out if this was done for other contracts?
For the question, I think as has been indicated before, there's an RCMP investigation. There is also an investigation within CBSA to look at this specific instance to see how this took place. I will say that we are very concerned and very interested in ensuring that the integrity of the procurement system. We are looking at these instruments. We're looking at all of our professional services contracting mechanisms to look at how can we ensure that they are above reproach, that they are effective, and that they don't allow these kinds of things to happen in the future.
I'm going to go back to the fact that I cited that there's no limit, and you confirm that there is no limit on commissions. So we could see half of the contract tendering going out to commissions. Why is it that PSPC has not been able to hire or recruit a human resource recruitment specialist for IT and pay them a good wage? I mean, the GC Strategies has made upwards 15 to 30% on their over $50 million in government contracts. Let's call it they made $10 million between two people that aren't even specialists in IT. This is a problem. If PSPC looking at how they're going to change this model, and I actually can see why they can't find anyone, because it's way better to be doing and more lucrative at what GC Strategies is doing. This has to be fixed.
Mr. President, I do take umbrage with the fact that there's no limit. As we've mentioned before, this is a competitive environment. People, the ultimate IT experts that are doing the work with the necessary experience and skills will not work for zero. They actually demand a wage. It's a
But the
highly
recruitment
competitive.
specialists are the ones that are taking the cut. I'm not talking about the workers. They're being exploited, clearly. The contractors, the subcontractors are being exploited. They're being exploited by these recruitment companies. Are you going to fix this recruitment process so that it's in-house instead of using these headhunters that are just milking the Canadian taxpayer?
That is our time. Perhaps you can get back to us on Mr. Johnson's next round. Mr. Barrett, please.
I'd like to start with Mr. Mills. Were any contracting rules broken on the ArriveCan app, yes or no?
No.
Were the contracts given to GC Strategies good value, yes or no?
Mr. President, I'm not in a position to assess the value for money of those contracts.
Okay, so the Government of Canada briefed you for this committee, and the documents on your website say on the fees charged by GC Strategies for managing these contracts, the rates were reviewed by PSPC officials and they were deemed fair and reasonable based on the knowledge of the commodity. So do you or don't you agree with your department's briefing materials for you in advance of meetings here at the Government Operations Committee for the House of Commons?
Mr. Chair, I would agree that the fees charged
Thank
were
you very
reasonable.
much. So to be clear, PSPC thinks that it's fair value to pay GC Strategies, a two-person IT staffing company, to get paid $11 million to use the advanced tools of LinkedIn direct message and Google searches for the ArriveCan app. So you think that that's good value? It's yes or no question, sir.
Mr. Chair, $11 million went to pay for IT specialists as well as the people that
We're
work
going to
for
circle
GC
back
Strategies.
to your briefing materials that said you believe it's good value. So we'll take that as a yes. They got paid millions and millions of dollars for this boondoggle. And the position of PSPC is that this is good value. The previous member asking questions wondered, why wouldn't you just hire someone to do this in-house? I have full confidence that the caliber of people working in Canada's public service are able to use tools well more advanced than the ones that the principals at this organization said that they use to earn their millions off of struggling taxpayers. Did anyone from your department who worked on ArriveCan receive bonuses? Yes or no?
Received bonuses. And executives, yes, during the period of this time, there would have
Okay.
been executives who received bonuses.
So the government's of the position that this is fair value. $11 million to a two-person staffing firm who did no work on this app. And we're to be told that the contracting system is fair. You know, a previous member said, well, they can't inflate the price. Well, obviously the price is inflated when there's the ability for ghost contractors and middlemen to make millions of dollars by subbing out the work and never doing a keystroke themselves. The relationship between this Liberal government, senior government officials, and insiders, consultants, and lobbyists it's incredibly frustrating for me, but the messages that I'm hearing from Canadians is that they find it that it's disgusting. We have Canadians who are struggling. We have, over the last 8 years, rents have doubled. Mortgage payments are up by 151%. More than 2 million monthly users of food banks, a third of those are children. And everything that has happened with the ArriveCan app and the responses that we're getting that this is fair value for Canadians' money, this is why Canadians have lost faith in the head of government, the Prime Minister. This is why they are losing faith in their institutions, because it's not reasonable to say, I don't find it reasonable or credible that we can hear that, well, it's fair value. You know, there's no room for them for the contractors to bid up higher commissions. The project shouldn't have cost $54 million if a couple of yo-yos in a basement using Google are able to collect $11 million. So if you need specialists on how to find some savings, I'm sure that there's people who are a lot smarter than me who can find ways other than that big red circle that I just drew around the $11 million. I don't have any more questions.
Thank you, Mr. Barrett. Mr. Pawlowski, please.
So I've got a lot of questions, and I have to admit, I came into this book in chapter 12, so I'm trying to still figure this out. But there's been the allegation that the resumes of a couple of bottler employees were doctored to make them look better than they were, to make it 10 years that they were of experience they had when they didn't have that experience. Now, am I right, Mr. Mills? You said that it's actually the departments, not PSPC, who has the task of ensuring that subcontractors actually have the ability to do the tasks that they're entrusted with. And so in this case, would that be CBSA would be the ones that would be responsible for looking at the resumes, or would it be you?
You're correct in the sense that it is the responsibility of the department, in this case CBSA, to determine what their needs are, what the criteria that they will evaluate against those needs and set the grids, and then actually to undertake what we would call the technical evaluation of looking at the qualifications and experience of those resources against their need.
Now, am I right, or did I get you wrong when you said that PSPC enters into 10,000 different procurement agreements per year? Is that correct?
Mr. Chair, we undertake 10,000 contractual items a year. So a large part of that would be entering into new contracts, and the rest would be things such as issuing task authorizations or amending existing contracts.
So it would seem to me that it requires a lot of departmental time if they're going to assess the abilities of subcontractors to perform the tasks and do such things that look at the resumes of everybody who's subcontracting. Is that the case? How many people are employed in our government to do this kind of work in each department?
I would say, Mr. Chair, it's not that simple in the sense of each department will provide departmental resources. So in many cases, there would be a project. So there'd be a team that's working on the project that would undertake the evaluation of those resumes and whatnot. It's not necessarily that they have a dedicated team to review resumes and do the technical authorities. It's really on a case-by-case basis, based on which unit of the department is undertaking that. In some cases, their own internal procurement folks will assist them, but it varies from department.
Oh, just out of curiosity, given the size of the government and the number of subcontracting agencies and a number of resumes which must go to the government, like how can you prove anyone's resume? I mean, I've sent my resumes to enough places, but I don't know that anybody actually goes to the university and says, did Marcus Pulowski really get his MD or his LLB from your university? So, I mean, how much really checking of resumes occurs by the government?
That's a good question for technical authorities about how much they validate the information, and their focus is really looking at the resumes and seeing if the years of work, the types of experience are related to what's being requested. I'm not sure across departments what other levels of investigation verification they do of the actual, did they attend this university to the resume. What I can say is that through the procurement process and within contracts is representations and warranties on the part of prime contractors that they attest to the validity of the information in those resumes.
So that's the prime contractor has the obligation to attest to. Okay. The second thing we've heard from several members of the committee questioning what value, if any, companies like Dalian and Coridex provide for the charges and the government money they receive. I wonder if I could ask you, because I would have thought, okay, you might question spending a lot of money on these sort of intermediaries, but I would have thought they perform some valuable tasks which take time and save those tasks, because the question was, why don't you deal with subcontractors directly? Do they not do a fair bit of the administrative things that are required in order to get something done for the government? Is that not the value that they add?
Very brief answer, please.
Mr. Chair, I'd say they add a number of values, but one is sourcing people with the skills, putting together teams, and then yes, they do manage a lot of the administrative tasks in terms of payroll and whatnot for those consultants and managing the legal relationships in between.
Thanks, Mr. Mills. Mr. Genuis, please, for 5.
What's the timer? Thank you, Chair, and thank you to our witnesses. Ms. Durgan, I understand that you were the signing authority for ArriveCan with GC Strategies. Is that correct? You were the person who signed for the contract, oversaw the contract from PSPC side.
So there were several contracts that I did work on, yes. And I did have certain delegation of authority, but I also received approval authority depending on the value of the requirements. Depending on the value, it would be what level I would go to, whether it be ADM or senior director.
Okay. Do you know who was responsible for making the decision to choose GC Strategies over Deloitte for the ArriveCan contract?
For the initial ArriveCan contract, it was CBSA that approached us with a procurement strategy for sole sourcing, and they presented GC Strategies to PSPC.
Who was the person from CBSA who brought that to you?
I don't know who brought it to us directly from CBSA. We received a package from them, but I don't know who made the decision. I have no oversight.
It is a matter of dispute that has led various CBSA officials to accuse each other of lying in terms of who actually made the decision. Does anybody on the panel know or have any information that will help us know who made that initial decision? No. Okay. To your knowledge, was Deloitte, quote unquote, in the penalty box?
No, not to my knowledge.
Okay. Would you have signed contracts with Deloitte around the same time that you were signing the contract for ArriveCan?
I would have to go back and look at that time frame, but I mean, I work on a lot of contracts.
Okay. But
I guess I'm not understanding what the question is or what the correlation is between whether or not I signed anything with Deloitte with
Well, it was-
respect- or with GC Strategies.
so
signing it.
the context is that a bid was put in by GC Strategies and by Deloitte for ArriveCan. And the decision was made to go with ArriveCan on the basis that allegedly Deloitte was, quote unquote, in the penalty box, which meant that contrary to the claims of Mr. Mills, this is a competitive situation. It wasn't a competitive situation. Deloitte was allegedly excluded from consideration for reasons unknown,
Point of order,
and that
Mr. Chair.
meant GC Strategies was selected. So
One moment,
I'm-
Mr. Generals. Yes, sir, go ahead.
I
If it's a point of
bel-
order, please, a real one.
Well, I know it's not a real one, but I just as a clarification, I
Okay.
think it was.
come on,
Butler.
come on. He
It was
admits it's not a real
That's
point
not
of
a real
order.
point
Just
of
be
order.
quiet.
Can
Let
we-
me answer the
was
question.
Butler.
All of us, Mr.
Sorry,
Jahari.
all of us,
Thank you for
please stick to real point of orders.
it's
Go ahead,
pretty
Mr. General.
disgraceful there. Chair, can I get some clarity then on the issue of penalty box? As far as you know, nobody was in the penalty box. Signing contracts with Deloitte was fine and permitted during this time. Can I actually talk to the people who do the frontline work? Thanks.
I have no knowledge of Deloitte being in a penalty box.
Okay, Mr. Mills, very quickly, do you have any knowledge of Deloitte being in a penalty box?
Mr. Chair, I do not have any knowledge.
Thank you
of
very
them
much.
being
Thank you very
penalized.
much. Would you be able to, Ms. Durgan, provide us with detailed information about, for the ArriveCan contract specifically, which companies got certain amounts of money? How much went to Carotix? How much went to Dalian? How much went to GC Strategies? How much and how much went to other subcontract entities? You have all that information?
I do not have that information.
Okay, does anybody have that information in the government?
Mr. Chair, we would have the information of contract values that were awarded, but how much actually was expended would have, and some of the task authorizations would have to come from CBSA.
Okay. We seem to have gotten the runaround a little bit. So I hope there's maybe agreement from the committee to request that information from both entities. How much money went to each entity? We can request the information from CBSA and PSPC, and whoever has it will give it to us. Is that agreeable?
More specific, just for the clerk, so she can note it down.
Yeah, I mean, I'd like the breakdown of how much, as part of the 54 million that was spent on ArriveCan, how much went to each company. Who were the people that received money as part of that contract?
Just one moment, please. Yeah, that's fine. And deadline, please, Mr. Generous, the usual 3 weeks.
Sure, that's fine. Yeah.
We will follow up, but the clerk will follow up with the exact details.
Thank you, Chair. So fundamentally, your department is responsible for assessing value for money in the context of procurement. I understand that to be part of your responsibilities. And I've been able to find a list of apps that were developed under the previous Harper Conservative government, apps that are complex in nature, apps like the CRA Business Tax Reminder app, the CBSA E-Declaration app, Canadian Armed Forces app, etc. All of these apps were developed in most cases for well under $500,000. In one case, for closer to $3 million. This particular app was developed at costs that were dramatically out of proportion with the costs of other apps that have been developed previously under the previous government. doesn't this suggest that your department failed to do its job in terms of achieving value for money? Ms. Durgan, did you want to intervene on that?
I don't have any visibility on that with respect to value for money. I work on individual contracts and we do our due diligence with respect to, competitive processes and,
Okay, so who's
evaluations
looking
I'm
at the
afraid
value
that
for
is
money
our,
piece then? Is
yeah,
that
I'm
is that you,
afraid
Mr.
that's our time. Mr. Kuzmirchuk, please, for 5.
Thank you, Mr. Chair. And I wanted to say, start off by saying, thank you so very much, Ms. Durgan, Chan and Mensur for, again, your service, the many years of service that you provided to this government, to procurement and to IT. Thank you so much. And thank you for taking the time to share some of your expertise here. Question to Mr. Mills. If PSPC became aware of embellishment, for example, CV embellishment that we heard in order to allegedly for companies to win bids, help them win bids. If you came across evidence of CV embellishment, what are some of the steps and repercussions that PSPC would take?
So under the code for procurement, we do, if they are, suppliers are supposed to act honorably and ethically. And if we were to find out that they were not doing so and that they had misrepresented themselves, we could stop work on a contract. We could set aside a contract. And if it was founded, we could terminate for default.
Is it possible that also that vendor would also be banned, for example? Are there situations where, again, if somebody, if there's misconduct, where again, CV is embellished and whatnot, could that certain company be banned as well too from future procurement?
Yes, Mr. Chair, there are vendor performance measures where we could actually suspend them from being able to do business with the government of Canada for a period of time. And in extreme cases, if there was criminal findings of fraud and the like, they would be, the integrity regime could come into play and they would be disbarred for, I believe, 10 years? Up to 10 years, they could be disbarred.
And even if it's not, even if it doesn't rise to the level of, let's say, fraud legally, for example, how long would something, again, like CV embellishment, whatnot, how long would it, would that stay on the record, let's say, for future bids? Is that something that PSPC would take into consideration? I'm talking about the whole gamut of misdemeanors, let's say, against an organization. Everything from misdemeanors to fraud. Is there a track record? Does PSPC keep sort of tabs on bad behavior?
I might ask Levent, who's a long career in procurement, you may have better examples.
Yes, thank you for the question, Mr. Chair. Under the vendor performance corrective measures policy, we do keep track of terminations for default. In the case of a false certification, that certainly would be grounds to terminate a contract, for default, and that would remain on the record for a period of time, depending on the severity of the termination. That could also result in debarment, either on the first offense or subsequent offenses.
How severe is CV embellishment, let's say, when someone is submitting to try to win a contract? How severe is that in the eyes of PSPC?
It is a very severe occurrence. There's also a framework to actually assess the impact on the specific client and the project and what that might cause in terms of damages to the Crown. And from there, there's an assessment that is made to determine the ultimate outcome of the penalty.
So there is a framework in place, a process in place to determine how serious that misclassification is.
Correct.
That embellishment is. Okay. Investigation of misconduct, for example, is that the responsibility, like in this situation, would that be the responsibility of PSPC, or would that be the responsibility of the department, CBSA in this case, to further investigate that misconduct? Who takes the reins on investigating a misconduct?
Mr. Chair, we within PSPC have a departmental oversight branch that, and they have within their unit and then kind of an investigative group that would look into it. They would typically coordinate with the client department and based on the situation, decide who would be the lead and how they would collaborate.
Is that what's happening here with the investigation of Butler AI currently? Who's taken the lead on that? I understand CBSA is doing its own internal investigation. Is PSPC part of that investigation as well too? Was PSPC part of that?
To my understanding, Mr. Chair, our department has assisted them, but certainly it's CBSE
that's taken the lead. Okay. Question for you. In the procurement process, when CBSA comes to you and wants to hire, for example, vendors, do they usually come to you with choices? Like, here are the 3 horses we're looking at, and then PSPC makes a final determination which is the best one, or do they come to you with one, and then PSPC simply investigates one, or do both things happen?
That's our time, but maybe you can offer a very brief answer, Mr. Mills.
In most cases, they come to us to use the TBIPs, which has a requirement to actually compete it to a number of firms already pre-qualified on that instrument.
Thanks, Mr. Kusmirchuk. We'll go to Ms. Vignola and then Mr. Johns. We're going to combine their 2.5 for the next 2 rounds. So it'll be 5 and 5, and they'll be done for the day. Ms. Vignola.
Merci beaucoup.
Thank you. Mr. Osmutlu, there are 2 contracts associated with ArriveCan, and those contracts were 33% of the contract were for Indigenous companies. But only a gentleman, Mr. Yeun Adelian, is Indigenous. He said he did have subcontractors from an Indigenous subcontractors, but couldn't say who. The idea for this is to not only give more contracts to Indigenous people, but to help them acquire expert knowledge and skills that are useful to them, to Canada, and to the economy. First question, if only one person comes from a First Nation and is an entrepreneur, is that contract automatically counted as being part of the Indigenous contracts strategy?
Thank you very much for the question. In the case of the procurement vehicle that we're talking about, which is the TBIP supply arrangement, there are a number of Indigenous firms which are qualified and which are eligible to compete for business that is directed under that stream. And that would determine the winner of that contract. In this case, it was Dalian and Corradix.
Je pense que ça, j'ai compris.
That I have understood. But if within the company to which the contract is awarded, if there is one single employee who is a member of the First Nations, and if that happens to be the business owner, is that enough for that company, Dalian in this case, to be awarded the contract?
Requirements under the PSPC program are administered by Indigenous Services Canada, who will periodically audit the companies to ensure that they are in line with those requirements. As indicated earlier, there are some content requirements which must be met in order to meet that requirement.
Donc, il devrait avoir plus que...
So there should be more than one Indigenous person. That is how I understand it. But as I see it, the company in question needs to have more than one Indigenous person who is member of the First Nations to be included in the strategy.
Thank you for the question. It's more about the value that's delivered as opposed to the number of employees in this instance.
Je vous pose cette question.
I'm putting this question because what I basically want to know is this. How can we ensure, how do you ensure that a company engaged by a member of the First Nations doesn't serve as a screen for a different company associated potentially with it, solely for the purpose of obtaining contracts and without any goals that are actually in line with the strategy designed to empower the First Nations? How do you ensure they're not being used as a screen and being abused?
Thank you for the question. This is what the pre-award audit that's conducted by Indigenous Services Canada would determine, is that they meet the requirements of the program, which would be to adhere to all of those rules. And PSPC would award those contracts based on the fact that these companies are on the Indigenous Business Directory, which is managed by Indigenous Services Canada.
OK, donc s'ils rencontrent...
So if they meet the requirements, that's all you need. you don't delve deeper to check whether a company owned by a person from the First Nations, well, that's enough. That's where you stop. Regardless of whether that First Nation person is actually doing anything tangible and may only be serving as a smokescreen. As long as your basic requirements are met, that's it. So how does that actually provide the First Nations with the kind of value that would serve to enhance their autonomy, their independence?
Thank you again for the question. As indicated, Indigenous Services Canada is responsible for administering the program, and the PSPC procurement activity is in line with those policies. And we do check to ensure that the companies with whom we contract are in fact on the Indigenous Business Directory, and that is our responsibility.
Merci.
Thank you. Mr. Johns, please.
Okay. In these contracts, Dalian, Cordex, and GC Strategies, they're taking care of the most basic core administrative aspects of contracting for the government. You've affirmed this. Now, how is it possible that the federal government, with all its resources, doesn't have the capacity to execute its own security clearances and take care of its own invoicing and payments? And how are we going to fix this? Yeah, Mr. Mills, I think you could take it.
Mr. Chair, the government does do projects by itself with its own staff. And in other cases, they have time limited projects where it does not make business sense for them to go out and directly engage resources within their departmental responsibilities to undertake their projects. So we make these vehicles available on an optional basis to serve departments when they've decided in their own terms that it makes sense.
And you see in this situation, it's turned into be a disaster. Are you going to fix it?
Mr. Chair,
Like, are you going to come forward with changes?
Mr. Chair, as I've mentioned before, based on what we're seeing here today, we are in terms of training, delegations, and whatnot to make sure that they are administered effectively in the future.
Okay. My colleague across the table, Mr. Souza, stated that none of the work can be subject to price increases once it's assigned. It's just private companies negotiating over the slice of the pie, and the government can't increase the task value once it's assigned. But that's clearly not true. We've seen task prices absolutely balloon after they are Butler, that when Dalian was brought in through a pass-through and demanded 15% for doing so, CBSA was pissed, is what he said, at the resulting price increase. And that email is public. I want to clarify all of this on the record because I find it very inaccurate, and I want Canadians to hear the truth on this.
Mr. Chair, as was mentioned earlier by some of our team members, when the contract is initially set up, there are rate guides within there, and in administering task authorization subsequent to those contracts, they have to respect those limits.
Okay, I'm going to go back to the fact that we don't know, there is no limit on how many people can take a cut of a contract. Have you done an analysis on this, on the ArriveCan app, on how much commission went out in the total value of the 54 million spent on the ArriveCan app?
We have not undertaken that analysis.
Would it be something that PSPC could do and then report back to the committee?
Mentioned before, we had set fixed limits for the resources. We see what the invoicing is based on those fixed limits, but I do not have the information below what has been invoiced on the fixed rates to determine who got paid what. Those are internal business relationships between prime contractors and their subcontractors.
And I think the public has every single right to know the answer to that question. And I agree, with my colleague, Mr. Kuzmirchuk, about the value and appreciation we have for the work that you've done and the commitment all of you have made to Canada. It's really hard to be in a committee setting and be pressing you like this, but people are struggling and they're not getting the answers they need. And I have to say, I've heard this isn't good for the morale of public servants when they hear a company taking $11 or $10 million slice $55 million in contracts when they're not even experts in that field. Are you looking at fixing it to bring in-house the capacity to, and replace these subcontractors that don't have the expertise to do that work on behalf of Canadians in-house? Are you looking at doing that?
Sorry. Again, Mr. Chair, each project, each IT arrangement is done within the authorities of a department. Departments will determine what's the best way to actually deliver that and what resources they can have. I will just say that some projects require very specific skill sets that a single department would not typically have, nor would it make sense for them to engage and to employ for a significant period of
I
time.
have time for one last question. Ms. Dutt, she sent an email 2 weeks before that email. CBSA was looking at, helping support their project and actually looking at assigning more additional resources. She sends an email the next day. Her contract gets cut. Do you not see that as reprisal from the government of Canada? The timing just looks obvious that it's reprisal. Is this common?
Mr. Chair, I cannot comment on that. I have no knowledge about it.
Okay, thanks, Mr. Johns. Ms. Kusi, please.
Thank you, Chair. Ms. Chan, I'm looking at the email from Ritika Dutt on Friday, May 26, where she states, while work was done for the implementation of Bottler's solution in the CBSA, we did not agree or consent to be named on this TA or for the work to be implemented under this specific TA. Since our personal information has been used by Caratics to implement the task authorization, we are requesting that Caratics produce any documentation claiming to contain our consent to be named as resources in this TA. We also request documentation of alleged correspondence and feedback between Bottler and Caratics during the implementation of this TA, including naming Patrick Van Ambiba as a resource based on Bottler's feedback. I then look at your response, Ms. Chen, on June 5th, Monday, June 5th, 2023, in an email back to Ms. Dutt, which states, in light of the facts presented to us, Canada has determined this matter is an issue between the three parties, yourself, the contractor, Dalian Enterprises, and Caratics Technology Consulting in joint venture, and the third party, GC Strategies. No further action required on our part. When you got that initial email from Ms. Dutt, who did you consult with?
Thank you for the question. I consulted with our legal advisor at Justice.
Okay, did you consult with anyone else on your team? Did you consult with Ms. Durrigan? Did you consult with
Yes.
Mr. Mills?
Yes, absolutely.
Okay, and what was their recommendation at that time?
To investigate the matter and bring it up to Dalian and Caratics.
Okay, but who made the final decision that this wasn't that this wasn't the problem of CBSA that you could resolve yourself at? Who made the final decision that you could simply say back to Bottler that we wash our hands of this? We consider the case closed from our part. You're going to have to work it out with the other individuals. Who made that final decision?
It was a collective decision.
Who made the final decision? There must have been one person that said to you, Ms. Chan, you know what? We're not going to deal with this. We're not going to get involved. This is the way it is in the government Canada. People get paid outlandish amounts. This is the way contracting is. We just sign the sections. I was very fortunate to be with Global Affairs Canada for close to 15 years. I was a management consular officer there. I've been through procurement strategies. The training, I'll admit I haven't received the extent to which you have, but it's very clear the outlines for what classifies for a sole proprietorship, when these conditions are not met, what it is, that when there is a contract you are drawing from with a preferred supplier, that it is astounding that these contracts are 4 times over the amount. The rules are very clear. They're very precise, but at the same time, we have our own judgment as individuals and as teams where we go, this doesn't make sense. This is an outlandish amount, or this doesn't make sense. And at some place, the buck has to stop, and it's somewhere someone has to take responsibility. So who made the final decision that it was not for you to decide? You can wash your hands of it. Your organization could wash your hands of it, and you could just write that note to Ms. Dutt and say that that Canada is not involved, and you have to work it out with these other 3 shady companies.
I will reiterate, I'll repeat myself that it was a collective decision that was based on the evidence that were provided by the contractors. That was also in consultation with our a legal advisor. I I came to that conclusion. I shared that conclusion with my supervisors, Ms. Mansour, Ms. Durgan. We all three of us agreed. I executed and I sent the email.
Okay, so you're taking personal responsibility for that. I have some more news for the committee. In that June 5th email, it does say Canada has determined. Well, Canada, as outlined with under the Government of Canada buy and sell website, that Canada is defined as His Majesty, the King and Right of Canada, as represented by, wait for it, the Minister of Public Works and Government Services. So Canada is someone. It is a minister, and they are ultimately responsible for what has happened here today. Mr. Chair. Mr. Chair, with my remaining time, I would just like please to check in on the situation with Mr. Doan, who of course appeared before this committee previously, and we had discussed based upon the outcome of his initial appearance that we'd be interested in having a further conversation with him. Where are we at, please, with his appearance?
We have not set a date or a request or an invite to him just yet.
Okay, we'll be doing that.
We'll send in an invite, yes.
Okay.
And the other ones were, I understand, the other ones named the other day were, we'd agreed there'd be a summons for them.
Okay.
But for Mr. Doan, it would be an invite.
Okay. Has he showed any reluctance to
We
appear?
haven't-
Because if there is, I'm ready to
We
present
have
a motion to
not-
summons him.
We have not contacted him
Okay,
yet.
all
but I
right.
do worry that, as we've seen, a fair amount of reluctance for witnesses, period, to show up today.
Okay,
I'll be
well, I hope
honest.
he's listening and he understands that he certainly can be summoned as other individuals have been. Thank you, Chair. Thank you.
Mr. Shawari, please.
Thank you, Mr. Chair. Welcome to the committee. And right off the bat, did any of you three show any reluctance to come to this committee?
No, we did not.
No, thank you. Okay, I'm going to follow up on the line of questioning that my colleague MP Kuzmerchuk started. Probably I start with Mr. Mel. Mr. Mel, when the ArriveCAN requirement was submitted to PSPC, to your department, was there a number of firm identified, or did you guys go through the approved list that you had and then you run a, what was the process?
Mr. Chair, thanks for the question. To my understanding, with respect to the GC Strategies contract, CBSA approached the department and said that they have a requirement to move quickly to build a technology solution to support their administration of the borders and to protect the health of Canadians on COVID-19, and that they'd identified GC Strategies as a firm with the ability, the readiness, and the capability to do it, and they had a sole source justification for why they were going to go forward with that firm.
Okay, so PSPC did not run any process because it was identified as a sole source.
This was April 2020. It was the
Sure.
eye of the storm of the pandemic, and they needed to move urgently, and they had identified this company and had a sole source justification, which is in line with the emergency contracting authorities at time.
Out of the 10,000, let's say, and I hear the number, so I'm referring, out of the 10,000, how many of those contracts went through such a sole source process? Roughly.
Mr. Chair, I'm sorry, I'm drawing a blank, but I would believe on an annual basis, we're probably more than 80% are competitively awarded in terms of our contracts. We'd have to get back to you with the number.
Okay, please do. I have another question, and anybody can answer that. Does PSPC at any time look at the scope of the work, or you just say, okay, we understand what the ask is, and you go out and look for vendors? Do you look at the scope of the work and look at the type of resourcing that's needed?
Mr. Chair, we do look at the scope at a very high level, particularly with respect to these instruments, because there are We need to make sure that there are different streams within the TBIPs, and we need to make sure that the scope of work is aligning with the appropriate stream. And then
Okay.
once contracts are bid and proposals and task authorization put forward, that the actual work is aligned with the stream that was initially awarded when we awarded the contract.
So the reason I'm asking, I'm going down that path is because we've heard from, now I'm talking about Butler AI. We've heard about the fact that in Butler's mind, they were doing a pilot and they were doing a proof of concept. And in the CBS's mind, they were doing a feasibility study. Those two are completely different things. When you were evaluating, or where your department was evaluating that contract, is it your understanding that the primary contractor deliverable was a pilot, or was it a proof of concept?
Maybe I'll turn to my colleagues. My understanding with that piece of work, the key focus was the task authorization. Was it aligned with Cordix Dalian's requirement to provide IT services? So it was IT services on the task authorization aligned with the scope of IT services. I do believe that it was more of a study, a feasibility piece on the TA, as opposed to identifying Bottler or identifying specifically piloting the implementation of AI technologies.
So you're saying it was a feasibility study rather than piloting. Ms. Chan, can you add anything to that?
I just want to mention that the original contracting authority who was responsible when that TA was issued is not with us, but what we have on file. Basically, for the scope of the contract, whenever we have an issue, whenever we have a TA that comes to us for signing, we verify to make sure the scope of the TA aligns with the scope of the contract. For this particular contract, it was for general informatics professional services in relations to feasibility and new technology aligning with CBSA's business and security systems. AI
Sorry,
was
time, I'm afraid, Ms.
part
Chan.
of that. It
Mr.
was
Brock?
in line with the scope.
Thanks. Mr. Brock, please.
Thank you, Chair. A couple of housekeeping matters to you, Mr. Mills. You referenced that a number of people within the PSPC received bonuses. Would you please table all the names of all employees at PSPC who received bonuses during the ArriveCAN creation, implementation, that period of time, please? Would you do that?
Mr. Chair, I'll take back to see what we can do in terms of presenting information about the compensation of public servants. I believe it's up, some of it's public, but I will take back in terms of what.
I'm specifically asking for the bonuses.
Well, the bonuses are part of the compensation package of public servants under our compensation arrangements. Yes.
So you'll do that then, sir?
I will endeavor to take back. I'm not sure from a privacy perspective if I can.
Your
make
public
that-
servants.
Yeah,
There's
we'll
no
take that.
privacy issue here. Would you further table the NDAs that should have been signed by the Bottler company, the resources for TA 2021002043?
Mr. Chair, I'll have to take that under advisement, see if we have them. So.
Wait. All right, take that for now. Ms. Chan, going back to my line of questioning about all the consultations you had with the DOJ. During any of that period of time, did any memo, did any direction, did any telephone call, any email go to the actual minister? At that point was Helena Jazik. Did anything go to Minister Jazik during that period of time?
I do not have visibility on that, so not to my knowledge.
Okay. Now, my last line of questions can be answered by anybody. Globe and Mail on November the 7th reported that President Aaron O'Gorman of the CBSA had asked on November the 3rd, had asked PSPC, and that they agreed to temporarily suspend all CBSA contracts with GC Strategies, Coridex, and Dalian, that the suspension could last up to 180 days. Although these allegations and investigations are not about ArriveCAN, she says, I recognize the ongoing audits and investigations may yield findings relevant to that procurement. Now, Canada found out, all of Canada found out on October the 4th, 2023, through another Globe and Mail story, that the RCMP was investigating GC Strategies as the sole source contract with the CBSA and Bottler, based on the evidence heard regarding the offenses of forgery and fraud were under consideration. Yet 20 days later, October the 24th, PSPC invites GC Strategies to tender on a temporary help service request. Why? Why? You knew they were under RCMP investigation and you're inviting them to tender yet again. And this is for, get this, computer support on a temporary basis, asking a two-person company who works out of their basement, who doesn't provide any service, who's under criminal investigation, to tender on this. Why?
Mr. Chair, we currently have a number of supply arrangements and methods of supply to which GC Strategies is currently a member of those methods of supply. When a requirement comes in under the rules, in some cases, the contracting officer is required to go to every qualified supplier on those instruments and ask for a proposal. So in this case, it would have been
Regardless of whether or not they've received national attention under criminal investigation, you know full well they've lied at committee. Mr. Firth has lied at committee. He's committed the act of forgery and fraud with respect to changing resumes, and your department thought it prudent to include him in a tendering process, knowing full well that he doesn't have staff. Why couldn't you simply reach out? This is for temporary staff. Why couldn't you put an advertisement on LinkedIn or an advertisement on the internet asking for help? Why did you need a consultant to do your basic work? Why?
Mr. Chair, these instruments have been put in competitively. Many firms have bid these, have spent time to get on these arrangements. A requirement, I'm not familiar with the full details, but I can imagine that a requirement came in for services under this instrument, and our procurement officers would have administered the instrument as per the rules. As we mentioned before, they're under investigate. GC Strategies is under investigation, but they are still member of these instruments.
That's our time. I understand we're going to Mr. Pawlowski, please. Go ahead.
So Mr. John has brought up the fact that we're wasting a lot of Canadian taxpayers' dollars and that we have these cascades of contracts and subcontracts and everybody takes a bit of a cut, and why don't we do something to address this? Well, isn't what normally happens, what prevents this is the competitive process. So if you have a lot of people taking a cut of the pie, you're not going to be able to provide or bid for a service at a reasonable price. So that keeps people in line and keeps this kind of waste from occurring. Is that normally not what happens? And it was not the problem under COVID, the fact that you tried to and had to get out something really quickly. And so you couldn't go through that normal competitive process.
Tried to explain before, but maybe I'm not, is that these contracts are ultimately about IT professionals doing work. Those IT professionals have very unique skills, very sought after skills. In many cases, the competitive process is, and these firms are very challenged to actually find available resources that will be able to come and do the work for the government of Canada. So in those circumstances, there is a market rate for these sought after resources that does actually place limits on what you could have for overhead. Ultimately, the fixed rate daily per diems for the resource is competed, and those firms in turn have to offer compensation that is amenable to those scarce resources to attract them, to make them want to come and do the work for the government of Canada. And that in that environment, the competitive process does put into and reduce the overhead and the profit in these industries.
Now, you must have been involved in a lot of different procurement processes under COVID. And I would have thought, or is it were there a lot of single source contracts awarded under COVID because of the time frame that was involved? And is there a concern that a lot of the companies that we contracted with, because there was no competitive process, because of the urgency, were allowed to charge an inflated rate?
Mr. Chair, it is true that under the early days of COVID, for many commodities, there were not many suppliers, so we run or have enter into sole source contracts. We do, as a course of action, have price verification when we do sole source contracts. Maybe I'll turn to Mr. Osmotlu to explain kind of the work that we do in a sole source to validate pricing and to do price certification.
Yes, thank you, Mr. Chair, for the question. For sole source contracts, we do seek price support to ensure that the prices that we're paying are in line with market rates. That could be looking at a price certification from a vendor, essentially certifying that Canada is being provided the best price in line with other preferred customers. As well, we may ask for things like invoices charged to other customers for similar quantity and quality of the goods and services.
Parm, do you want to go if we have any time left?
You have a minute and a half, Mr. Baines.
Okay, just one question here. How could this one is to Mr. Osmotlu. How could the contracting process be modified to provide the federal government more oversight on subcontractors? And what trade-offs would be required to achieve this outcome?
Thank you very much for the question, Mr. Chair. I think, as a result of these proceedings and the investigation, we will take stock of whatever findings there are to determine what improvements are possible. We may seek more visibility on subcontracts. Currently, we rely on the private sector to organize themselves in order to deliver the goods and services that are being sought after. And in fact, many of the private sector entities are appreciative of that approach. And in fact, they want to be nimble and they want to make their own business arrangements in order to supply the goods and services. But if there's a requirement for more visibility in our contracts, we can certainly look at mechanisms to implement those.
You have 15 seconds, Mr. Baines.
I thank you for coming today and answering our questions.
Thanks, Mr. Baines. Mr. Generous for 5, and then we'll follow up with Mr. Suso.
Thank you, Chair. To all of the witnesses, was Minister Jacek involved in any discussions? Did she receive any briefing notes, any information, ask any questions regarding the ArriveCan procurement?
Mr. Chair, I'm not recalling briefings that I participated in. I'm not sure if aware of any that Mr. Jacek was involved with.
She's the minister responsible for procurement. This was a relatively high-profile project. Surely, did she ask any questions? Would it have been normal to let the minister know what was going on? I'm getting long pauses here. It's a little bit surprising.
So, Mr. Chair, at the time when a lot of these early procurements were going on for ArriveCan, the focus was certainly in the early days of the pandemic around acquiring PPE.
Yeah.
It was about inquiring about getting vaccines, about getting tests and tests.
Sorry, I know a filibuster when I see one. Was Minister Jacek informed of did she receive any briefing notes? To your knowledge, like it's a pretty simple question. Either she was kept completely in the dark and didn't ask any questions, or she was aware it was going on. Which is it?
So I believe she would have seen some products, such as our contracts that would have been done under COVID authorities, and so a number of the contracts. But the initial contracts,
including ArriveCan or not?
The initial contracts that were put in place with GC Strategies predated Minister Jacek.
Okay, Minister Mills, can you just answer the question? Did Minister Jacek ask any questions, ask for information, receive any information? Would that have been normal or expected?
Mr. Chair, to my knowledge, I was not asked to provide any briefing on ArriveCan to Minister Jacek. Whether someone else in the department, whether Deputy Minister, what, I would not
You
be
didn't
aware.
you didn't see any briefing notes go up. You didn't get any questions from her or receive any information at all. So
Mr.
she's
Chair,
either
I don't
just
rec- I don't
profoundly and curious about this relatively important project of the government of Canada. Does that seem surprising to you?
Sorry, I just don't recall. I have to go back and look at my records.
Okay, could you reply to that question in
Yeah.
writing to this
Yes.
committee? Thank you. I just want to confirm again, is it your department's job to ensure that taxpayers get value for money? Is that part of your mandate?
Mr. Chair, it is part of our mandate. Is
Excellent, excellent, great. So when you look at the fact that $54 million was spent on this app, and as I outlined earlier, you look at the fact that various comparable apps that were prepared under the previous Conservative government were done for much lower costs, generally under $500,000, in one case going up to $3 million. We're talking orders of magnitude more money. Did you look at this contract and say this isn't value for money, or did you look at it and say, "Yep, sounds fine, stamp"?
Mr. Chair, I think has been provided to this committee before. There's 46 different contracts that were used to produce the work related to.
Yeah, again, Mr. Mills,
But
sorry,
it's not
can we
a
answer the
single
question here?
contract for $54 million to build an
Yeah,
app.
can we answer the question? $54 million obviously sums up the work that was done on ArriveCan. So the question wasn't for sort of a regurgitation of process. You looked at the various contracts. Did you say, yeah, value for money looks good, or did you do what your job is supposed to be and ask some questions about this not achieving value for money?
At the beginning of the endeavor to build the ArriveCan app, we were not aware that there would be 46 contracts leveraged to actually undertake all the work necessarily internal to adjust systems, to actually design and to deploy the app on many platforms. So that analysis was not done at the beginning because we were not aware.
But at any point, so we established at the beginning that the minister was sort of incurious about this and unengaged from the process. Did at any point anyone in your department, in her office, herself, say, "Hey, we got a job to do, which is achieve value for money, not just put a rubber stamp on everything"? Did anyone at any point say, "This is not achieving value for money, guys"?
Mr. Chair, I cannot speak for everyone in our department in terms of who was analyzing the overall value for money.
Did anyone at
I'm
any
afraid
point?
that is our time. Mr. Sousa, please.
Thank you, Mr. Chair. I'm going to be sharing my time with my colleague, Mr. Kaczynski, as well. Couple of things, Eric. Sorry, I don't know how to pronounce his last name.
We knew who you're talking.
I'm pretty much new to the force. I need to pay. My apologies. A couple of questions very quickly here. Do you think Phoenix was good value for money?
Sorry, Mr. Chair, I cannot.
That's okay. I don't think none of us do as well. And then that was obviously a big piece. I think that went through badly. The bottler contract was a fixed rate contract. Is that correct? I think it was at 350,000 or something like that. Do you know, Mr. Chan? Ms. Chan?
You're speaking to, thank you for the question. You're speaking about the task authorization, which
Yeah.
is not a contract.
It was not a contract, but was.
It was part.
But
it
was the prime contractor fixed?
The per diem rates were fixed.
Okay. Mr. Mills, how many contracts are you dealing with annually?
We do 10,000 contractual activities a year.
How many of those contracts is the minister aware of?
In the tens, probably less than 100 that would require
Yeah.
ministerial approval.
They're not, that minister normally would not be part of the decision-making process, correct?
That is correct. And in the case of ArriveCan, of the 40 or the 31 contracts that we put in place, There was only 3 of them, I believe, that actually required executive approval. The rest were within
Okay.
the actual Angela's.
And when we look at contracts, and this is a service contract that's being provided for IT professionals that are not available to us in the bureaucracy and in the public service. I'm very interested and curious as to why the members opposite now want to inflate the bureaucracy with many more people and put them on the payroll when they want small government. But when you look at a contract and you have dealings for construction, for example, you got building contractors, right? You got the trades, you got the sub trades, you got a project manager, you got a construction manager, none of whom are employed by government, but you do provide contract bases enabling them to work. And everyone's making cuts in between, including those that are working union paid jobs to provide those services. Is this similar in this case?
Mr. Chair, I would say it's very, very parallel. It's in the case that these IT projects generally are to build a system or a tool and then leave it behind. So it'd be very similar to engaging an architect and an engineering firm to design a building, then engaging a prime contractor to actually build that building.
Okay, over to you, Eric.
I want to thank my colleague MP Susinski for his excellent line of questioning here. Mr. Mills, the Butler AI contract is a series of 6 contracts, deliverables about $70,000 a piece. You mentioned that PSPC looks after about 10,000 contracts per year. Where does it rank a contract like that of that amount, $70,000 in the grand scheme of things, relative to the number of contracts that you see? Is it a big project, small project?
That would be a relatively small project for us. We have multi-billion-dollar contracts, so this would be a very small task authorization.
Okay, got you. Mr. Ergen, you've been working in the public sector for close to 30 years, you said.
30 years, yes.
26?
36.
36 years.
30,
My
30
goodness.
years. Sorry.
Have you come across a situation where, for example, a company has inflated their bona fides? Like on the CV, like we've heard with Butler AI, with GC Strategies. Have you come across misconduct like that?
So thank you for your question. So normally, as was already outlined, is that normally at the point of a resource evaluation, if you will, that is a client responsibility. If it's at the TA stage, and then even at the RFP stage, the client is responsible for evaluation, the technical evaluation.
But have you come across in your experience, 30 plus years, have you come across misconduct when you're reviewing sort of contracts? And if you did, do you feel like you have the training and that you have the support from the department in order to be able to flag it and address it?
So I've never come across an instance where in this case, allegations were made that inflation of experience or resumes was done. So I personally have never had a situation.
Any other misconduct?
That is our time, Mr.
Thank you.
Kuzmierczak. Mr. Kuzmierczak. Witnesses, thanks for being with us. Mr. Mills, I just wanted to follow up on a couple of things. My colleague, Mr. Brock, asked a question regarding the bonus. I assume you'll just write back to us an answer, and I think I know the response, but you respond to us. The NDA, will you just provide it? You've mentioned you weren't sure you had it. Would you just simply provide it to us if you have it? Perfect. Thanks very much. Thanks everyone for being with us today. If there's not, we are adjourned. Thank you.